job you love, and you will never have to work a day in your life, said Confucius. A career is a long-term goal with several short and long-term plans. It is strategizing your milestones and keeping up with the preparation. You have to make decisions about the right subjects to pick, identify gaps you need to fill, extra readings, research, update, internship, self-reading, and assessment. Isn't it that a timely guidance and inspiration from a doyen in the relevant field provides us a better direction towards the destination? Today, we are going to explore career opportunities in the niche and fastest developing and perhaps already the most voluminous jurisprudence of insolvency and bankruptcy code, which is bound to further grow with frequent amendments and interpretations. Why is it so important? IBC is a key driver of economic recovery in India and hence ensures India's sustained economy. It ensures efficient movement of capital from inefficient firms to efficient firms. It is the reason why it is a composite practice area which demands expertise of a CS, a CA, a business manager, receiver, liquidator, and a lawyer. It engages services of insolvency professionals, IP agencies, IP entities, information utilities, and registered valuers. Clearly, it calls for quite a skill set and a keen understanding of the laws. Hello, ladies and gentlemen. I am Anubha Dhulia, and I heartily welcome you all. Today, I have this extreme delight and honor of introducing to you the speaker of the moment. He was recently asked at VW Legal, "What motto do you live by?" The motto, he said, "I live by is to combine passion with compassion in all we do, both in our personal and professional lives." He is the co-founder and senior partner of AZB Partners. He, who has over 39 years of experience, is a banking, bankruptcy, restructuring, infrastructure, and project finance lawyer. He acts for several distressed funds, insolvency professionals, domestic and international banks, and financial institutions. Considered as one of the leading restructuring and banking and finance lawyers in the country, he has been on several government-constituted high-level committees, including the Vishwanathan Committee on Bankruptcy Law Reforms, which led to the implementation of IBC. Through him, this webinar is an attempt not only to understand the career opportunities, but at the same time to instill in us all the same passion for our individual pursuits. Young ladies and gentlemen, to speak with us on shaping a career in IBC, we have with us none other than the architect of code himself, Mr. Bahram Vakil. Very warm welcome, sir. Please, the audience is yours.
Thank you so much, Anuba. Thank you, BR Foundation, Rishabh, and all of you, the audience who have taken the time out especially on a Saturday afternoon to come and listen. I do hope that you find it useful. So I'll start, if I may, on a broader note. I have to say, as I was mentioning to Anuba, that this is really tailored to students or very young lawyers. So apologies at the outset if there are some of my fellow professionals in the audience. I'm not sure how much you will benefit from this talk. But having said that, I will start with some very broad propositions which apply to all lawyers. And then, of course, I will go into the career that IBC promises for you. So I think to start at the broadest is that for all of us, but especially for the younger generation, I think the two biggest problems we are all facing today, and sadly, I think COVID has highlighted in some ways both these issues. One is inequality. So inequality, again, Anuba was very kind to say, the motto that I mentioned in my interview, that I think all of us have to combine success and passion with some amount of compassion, because just as it is said that unless we get rid of COVID from all, you will not get rid of it for each and every one of us. So the same thing with inequality. You know what is why I bring this up is that anyway we were going in the wrong direction. Even from in 2019, country by country, what you saw was inequality was worsening. Instead of bridging the gap, it was going the other way. The US, Europe, most all of Asia, including unfortunately us. So all that COVID has done, which I hope in some ways will prove useful, is that it has put the spotlight on this, and in a very dramatic way. Two things. One is that I think even on a conservative estimate, about 150 to 200 million people have slipped below the poverty line, and I dare say a very large number of those will be in our country. So you can see, and we know it anyway for a fact. We've all lived through it over these last few terrible months, that we are in this storm together. But I think a very nice phrase I heard is all of us are in very different boats. So for the poor, for the people with less means, it has been much more harsh. And similarly, as I say, this is just that COVID has brought this spotlight. I hope we will not forget what happened with the migrants last year. And I hope the world will not forget that we cannot continue in this way. We cannot continue where country after country, I keep repeating it, it is not only us. We have it acutely because still, unfortunately, at least 200 million people in India are poor. So, while we are the fifth or sixth largest economy in the world, we have fantastic potential. Please don't get me wrong. You all have a very exciting future. But it will be a much more exciting future if you carry everyone together. That's the only point I'm trying to make. And to emphasize the positivity of this is that it took us 60 years to reach the first trillion in our GDP. So from 1947 to 2007, in 2007, our GDP reached 1 trillion. Then in the next 8 years, 2015, we reached 2 trillion. And then just before COVID, in just 4 years, we reached the third trillion. Now, unfortunately, we'll have fallen back. Our GDP will have shrunk because we all know what happened last year. But imagine, from 60 years to reach the first trillion, you did it now in 4 years, and short of disasters like COVID, you will do it every 4 years. So there is no doubt that India will become the fourth largest economy in the world very soon, certainly in all your lifetimes. So the opportunity is unbelievable. Whichever sphere you are in, it is unbelievable. All I say is carry as many people with you. And on that, I've seen, and I'll come to that a little later as well, that all you need to give people is basic infrastructure, and which includes what I call hard infrastructure and soft infrastructure. So the hard infrastructure, all of you know. In fact, it's a large part of the cases in IBC are from infrastructure, power, roads, airports, all that. That's hard infrastructure, telecom companies. And soft infrastructure are, if not even more critical, and that is health and education. Again, we have seen it, how important health is, how badly it has come back to bite us. So if we spend one of the lowest of any country in the world, I think the third worst in terms of our spend 2% of GDP towards health. That is crazy. We definitely, and I really hope once and for all we get this right. Education, of course, we are much, much better. But again, look at the inequality. We have the number one edtech company in the world. You all know it, Baiju. Bar none. Not in the US, not in China. Nowhere is there a bigger edtech company than Baiju. And on the flip side, we still have millions of people who remain uneducated. So this dichotomy and tech will help us. We have seen all of us have been out of school, out of college, out of office, and we have managed with tech. So we can definitely get there. So that's my first huge request to you: live compassionately, live in harmony. And the second one, again, we don't have a choice at all, is climate change and what we call, the net zero commitment, which almost every developed country in the world has already committed to. You have a choice. Some countries say we'll do it in 20 years. Some people say 30, 40, but some hard commitment, because I'm again apologize on behalf of my generation that I think we have done a very, very poor job, and we are leaving this planet in a very bad shape. You can see it, with all the climate disasters that happen across the world with much more intensity. You can be almost sure, unfortunately, that every year we'll have some climate disasters. And therefore, there is really no choice. And we have run out of time. If we do not do this in the next 10, maximum 20 years, then the cliff is very steep. There's no going back. It's not even worth thinking about. So there is what they call the COP26 meeting in Glasgow in November this year. I'm sure before that there's the G20 meeting, I think next month in Italy, where of course India will be at the table. So I am quite sure and very hopeful that we will also sign up to a net zero commitment. I guess it will be between 2050, around that. So in the next 30 years, and China did it a couple of months ago. So I cannot see that we will not. It would be crazy because, as I say, we don't have a choice. It's again one of those things that you are in it together. You may be the richest, most powerful country, and you may be Afghanistan. You're in it together. If any country keeps polluting, the world is a worse place and climate change occurs. So, of course, again, per capita, we pollute much, much less than any of the developed countries. America being the worst, all of Europe, even China. The richer you are, the more you pollute, the more you consume. So I'm not saying that it's unconditional. We can decide that we need 10 years extra. We'll take till 2060. And we need X amount of financing, X amount in grants, X amount in soft loans, as we call it, which is 1-2% loans, so very low interest rates, and the required technology. And again, to give you a sense of the numbers and the opportunities, and this will all come in IBC as well, is that today we spend about $30 billion a year on green tech. So, electric cars, electric trucks, renewable power, wind, solar, all that stuff. To reach this, if we did 2050 as a target, in the next 10 years, we have to spend $160 billion per year. So we need $130 billion per year for the next 20, 30 years. So that will be the kind of ask that we will ask the G20. You want us to make a commitment. You guys are still much bigger offenders than us. We still have 200, 300 million to bring up to middle class. So then this is the technology we need. This is the money we need. And then we go for that. So those are my two very broad themes just for all of you to think, because as I said, it affects each and every one of us. And the last thing, because it's so critical, so obvious, any of you who can, convince the powers that be, the best investment in the world today, and I can give you that in writing. I'm sorry, it's not as exciting. I'm not going to give you a stock tip. is to give free vaccinations to everybody across the globe, all the 7 billion people we have. The return on that, this is not me, of course, it's, I think, the IMF who put out this report, is 1400% return. So the amount you lose compared to the amount you spend, is the return is 1400%. So 14x return. How difficult is that for anyone to understand? So we should absolutely, and I think because of the bitter lesson, and because very sadly Delhi was affected so badly in April, and again you saw from the richest, even doctors' families, to the poorest, you were running around for a hospital bed, ICU bed, oxygen. So I think now the situation is much, much better, and people have understood the need for this. But once again, it's across the world. The G7 just met last week. Said they'll give 1 billion, but the need is 7 billion, and the loss is, as I said, 1400 times 7 billion. And the same for India, because as I mentioned to you, our GDP probably went down 200, 300 billion in 1 year. 200, 300 billion. So, and how much would it cost us at 150 rupees to vaccinate everybody? So it is the easiest calculation to make, and I do hope we get there fast. Now, coming to law first and then IBC. So I have to tell you all that, it's not even recognizable. When I started, Anuba has already dated me, that I've been in it too long, 39 years. And there was the largest firm. I was very lucky to work in Little and Company. It was a 150-year-old firm. The two senior partners were still English solicitors practicing in India, who were qualified to practice in India. And, there was no question of specialization. If I said I just wanted to do bankruptcy law, they would have laughed me out of the office. So we did everything. I went to court. Our largest clients were SBI, LIC, Bank of Baroda, PNB. So very strong banking and insurance practice. And then, of course, a lot of corporate, etc. So you went to court almost every day. You did property matters every day. You did employment matters every day. I still, and again, because of these bad times, I think I've done maybe 40, 50 wills. I've drafted myself for friends and family in the last 1 year. But where did I learn that? I learned it on the job there. I did a lot of intellectual property somehow, mainly trademarks, of course, not so much patents. So you're getting the picture. Infrastructure, banking, finance, you did everything. So what I'm saying to you is, in today's world, yes, you have to specialize. There is no question about that. And therefore, those of you who have an interest in this field, as we'll go into it, it has fantastic potential. In some ways, it's a sad thing that it has fantastic potential. But there is no question. The next 4, 5, 6 years, it will be booming practice. And we will have much less practitioners than cases. And therefore, it's very good time for anyone in this space. But what I say to you, especially the students and the young lawyers, is in the beginning, be as broad-based as possible. Maybe it's my age, maybe it's the way we practice and the way we are at AZB till today. There is virtually no lawyer in AZB that does only one area of practice, myself included. So our head of litigation has done a lot of corporate law and is one of the top insurance lawyers in India. So he has done, more than half the insurance JVs in India. So all of us, even the ones in capital markets, have done regular corporate. For example, my work now, of course, the last 5 years, 6 years has been very heavily swamped by IBC. But I would still say that 20% of my work is other non-IB, little bit of banking finance, which is kind of related, little bit of M&A, and and other stuff, as I just pointed out. So be as broad-based in the beginning. Then if this is what you like, of course, dive in. You should be the expert. You should know this area really well. So you're known in this area. But I believe, this is my sense of it, that even if I look out 5-10 years, and I don't think any of us can look out more than that, uh, given the way India functions, the size of our economy, I would always say, please have a second arrow in your uh, uh, pack, so that have, whether it's broader banking and finance, if banking and finance is what you like, if it is some other field that you like, there is a lot of M&A in IBC. The fantastic thing about IBC, of course, there's a lot of litigation, unfortunately, in IBC. So the great thing about it is that it covers so many fields. So, of course, there's the core IBC, then there's litigation, unfortunately. There is, when I say M&A, when we represented Tata's to buy Bhushan, I mean, what is that? If it was not IBC, you'd call it pure M&A. Tata Steel buying another steel plant, or any. So in each of them, that is there. You have the due diligence, you have the share subscription agreement. So if you had not done M&A, you would be pretty lost. Then in any of these big cases, like the one I just mentioned, you have to go for CCI, Competition Commission approval. So our competition lawyers get involved. And then, of course, in almost all the cases, there's financing. Even a house like Tata's will definitely look to raise finance for the acquisition. So banking and finance gets involved. So you can see, you can choose which parts interest you, but certainly be broad. And that is why I feel that the English have got it right. That they, they have this thing called a trainee contract. And in that trainee contract for 2 years, before you become a first year associate, after you qualify, you have to do 4 rotations, as they call it. So 3 of those are compulsory. So you have to do litigation. I don't understand how you can be a well-rounded lawyer if you have done no litigation. Even when you're drafting an agreement, you will not understand which clauses are really crucial until you're faced with that in court and you get a lawsuit and you have to argue and defend those clauses. So, for example, the huge example right now is, the Amazon case with Biani. Now, those clauses are being challenged in court, as we all know. There's a big fight between them. And if the AZBIs who drafted that were not aware of how crucial those are and how you will have to argue in court, the drafting would have been less robust. So litigation is there, corporate is there, banking and finance is there, and then your fourth, they leave to you. If you, like, say you wanted to do bankruptcy, you wanted to do, I mean, whichever, competition or uh, intellectual property, you have the choice of the fourth. But these 3 core areas are compulsory, and then you move into your specialized area after 2 years. So I think that is pretty good. I think we should kind of adopt that in India. So that is my first advice to you all. The second advice, I think all of you know, is that, if you're going into law, it's a lot of hard work. So I'm not going to sugarcoat it for you. It's not continuous in every field that you're in. Certainly in IBC, there are ebbs and flows. So there are times you will be insanely busy. You will have to work till very late hours of the night. If there's a filing to be done, if there's a resolution plan to be put, just now we just finished with the Divan uh, court case. Of course, they will appeal, etc. But there were many nights, even now at this age, I was on the call till 1:30, and of course my team was working till 5-6 in the morning. But then there are lighter days. I don't want people to think that this is like forever and it's a burnout. That's not the case. I mean, we are all looking now for some kind of work-life balance. I know that The younger generation is much more sensible about this. So it comes and goes. But in the early years, is there a ton of hard work? Absolutely, there is. There is no question about that. And there are no shortcuts. Don't try for those. Again, there are big pluses and minuses in the younger generation. I guess you all are much more Google savvy. So those shortcuts can help you, but you can't not read the case law. You can't Google it and therefore say, hell with reading the main case law. That definitely won't work. And walk a straight path. Always sleep easy at night. I mean, if you do that, if you have a passion, you have put in the work, success is guaranteed. I know my colleagues won't like me saying this, but I always feel that this is not really a rocket science. It's not like a nuclear physicist or, one of those crazy genius kind of situations. It is genuinely 99% perspiration, 1% inspiration. So success is guaranteed. As I said, there will be so much work to do. So walk the straight path. Do not, then if there are integrity issues, that's it. That's a really bad scene. And I think once again that the younger generation is much, much better than our older generation. So I'll then move on to, quickly I can tell you small stuff like drafting is very important. If you think clearly, you'll write clearly. Short sentences are much better than long sentences. Even when you read, it's a pain in the neck to read long sentences, and you are apt to make mistakes. Fancy, complicated is not good. Simple, no jargon is much, much better. So that all that very basic stuff. And then I come now closer to IBC is that you have kind of three choices. So if you're going to be a lawyer, you have a choice of working in a firm like AZB, Amarchand's, all of Khaitan, etc. Or you can have counsel practice and argue in the tribunals and court. So if litigation gives you a buzz, if litigation is what you want to do, if disputes is what you like, then I would say start with a firm, because the foundation is very strong in a firm. The training is usually better in a firm. But thereafter, don't stay in a firm, is my view. Now, if you prefer the advantages a firm gives you, of course, in the early years, the pay at a firm is much better. It's much higher risk in counsel when you're young, because there may be many years you learn very little. So it's basically high risk, high reward for when you're successful. We all know what fees counsel charge. But my gut feeling is the action is in the court, in the tribunal. You want to do the arguing yourself. You don't really want to do the strategy and the drafting of the proceedings. Or then it is practice like all of us do, where we represent, which is, non-dispute. So we are doing everything else. So whether it's for the lenders, the COC as we call it, whether it's for the bidder, whether it's for the RP, the guys running the show, or the administrator, as you call it in case of Divan, because it's RBI appointed, whether it's for a domestic or foreign distress funds, the investors who put money in along with a strategic to buy the stressed assets. All that is then done in a firm. So there's the firm route and there's the litigation route. And then, of course, there is, as I said, the insolvency professional, which I think Anuba alluded to, that it combines a lot of disciplines. Because the day one, as you know, the minute the case is admitted, the board is suspended, the promoters are out, and this individual insolvency professional runs the show. So in the beginning, there was a lot of talk that say, because in the beginning we had the Dirty Dozen, which were all billions of dollars, huge cases like SR, etc. So how will an insolvency professional run such a massive steel company? But they did, and they did it extremely well. And we all know what happened in SR. They recovered fantastic amount. I think it was 43,000 crores. And the first offer was 12 or 13. So just because of IBC, the banks, instead of getting 12, 13,000 crores, got 43,000 crores. So you can see how much IBC achieved for the banks. And when I say for the banks, it's for you and me, because if the banks suffer loss, they need to be capitalized by the government, which comes from our taxes. So it's a pretty straight line. So this lady or gentleman, the IP, is not some superman or superwoman. They then can have their own team. They will have lawyers. So that's why I say we have, represented the IP many, many times. The big four, which all of you know, EY, PwC, KPMG, etc. Grant Thornton. There are some specialists like Alvarez and Masal, which is one of the global leaders. They were the IP in SR. And there are a whole bunch of others, and lots of one-man shows who also do a great job. In smaller cases, you can go to a one-man show, and then that one-man show is not running the entire company. He will hire legal advisors, financial advisors, valuers, technical consultants. So he just runs the team just like a CEO would run a company. So that's another thing. If that's what you want to do, much more responsibility, but fantastic success you can have. I dare say they must have earned a fantastic amount in places like SR, and it's as fulfilling as it is challenging. So those are the different roles, and with that, I think very, very quickly, I should also do a time check because I definitely want to keep. I think I should try and
Very much
finish.
within time, sir. It's
No,
just
but I want to keep it. I don't want to go more than an hour, and I want to keep at least 20 minutes for Q&A
sure, sir.
because it'll be interesting to keep it interactive. So pre-IBC, why IBC was that it was fragmented. There were too many different laws. Things fell through the crack. Uh, most of the credit in India came from banks, which is not good. In any developed market, you should have some financing from banks, but the really well-known companies should go to the bond market, issue bonds, and get their credit. So we were more than 80%. In UK, US, etc., it would be almost half and half. Now we are more than 70, so we have made some progress in the 4 years. But that was one of the macro intentions of the government. And then, of course, things were very bad. BIFR had come to a standstill. Recovery was 22%. It took 6 to 8 years. So you desperately needed the law. And finally, I think, operational creditors, as we call them now, all the others besides the banks, etc., they had very bad leverage. I mean, to get a meeting, if you were a small time supplier, whether of goods or services, whether it's catering, security, or supplying steel, I know if you were a small guy, you didn't even get a meeting. They just treated you so badly. And today they say that OCs are still, not getting a good deal. Actually, that's not true. If you go into the data in detail, the vast majority of cases today are being settled out of court, they say, or they call it, where the matter has been pulled. And this is because wherever it's a few lakhs or a few crores, nobody's going to risk their company. Because remember, I told you on first day of admission, you lose your company. So wherever they can, they settle. If it's a small amount, they just pay it off. And therefore, today, actually, some people say they have too much blackmail advantage. But, it says where there is an undisputed debt. So if you owe someone, whether, as I say, it's from the catering guy to a raw material supplier, if it is undisputed, then you should pay it. So now they will pay it. because they won't take it to IBC. So actually, today, the operational creditors have a lot of leverage. So now I come to how have we done? The report card so far. There's been a lot of, negative press. I'm obviously very biased because, as Anubha kindly said, I was involved in the drafting team. But, and there again, I'm very proud, as all of you should be. We are not known as a country to be the fastest guys in the world, but we finished drafting from scratch 13 months. Singapore took 3 years, and Canada, European countries took over 5 years. And then, even more incredible, and that is kudos really to the government and IBBI, etc., our regulator. In 13 months after the law was drafted and ready, it came into force. So, taking it through two houses of parliament, joint parliamentary committees, setting up a new regulator, brand new professionals. We were so worried there were no insolvency professionals. Today, in 5 years, we have more insolvency professionals than UK has in 30 years. So it moved incredibly fast. And I think it's fair to say that, yes, there's been an unbelievable body of law. The courts have been very kind. The tribunal also in large measure has done very well, but especially the Supreme Court, in that they give first priority to IBC cases. And therefore, what normally would have taken us, I would say, at least double the time, we have that many precedents in this short 4 to 5 years. And that is why, one of the things I do want to say is that some of these delays, better I get into it immediately, is that the first delay is admission. So because there's a huge backlog of cases, and again, of course, COVID has exacerbated that, but it takes too long to get admitted, way too long. It was supposed to be within a month. You can slip by a couple of months, you can't make it a year. So I think, it should be pretty straightforward, the admission. And if necessary, uh, if some tweak is necessary to in the law to make this faster, maybe we should do that. But the admission process is too slow. Second thing, of course, this is all our lawyers' fault, is that the settled cases, as I say, we have got Supreme Court has been kind enough to hear so much in IBC cases, settled so much law. You can't go beyond the Supreme Court. Those decisions, you don't need to waste time. In 10 minutes, the NCLT should move on. You don't need to hear arguments all over again because it's a very famous lawyer, whether it's Salve, whether whoever it is. I mean, be very respectful, but say this is settled by the Supreme Court. Please go to your next argument. Instead, it goes on for weeks, not for hours or days. It goes on for weeks. One small example, that the difference between a secured and unsecured creditor. We all know the difference between a secured and unsecured creditor. You will, destabilize the whole banking system if there is a difference between the two. Why is the Supreme Court itself getting into this again? It can follow its own precedents. This has been done. It was done by SR. SR went to Supreme Court on almost every issue some 6 times. Why did those judges waste their time? So I think they should be much quicker on that. And the last thing for the NCLT, which I urge with all due respect, is that we need a bankruptcy tribunal. Because actually, company law cases are suffering very badly. Because as I say, as you all know, they hear both company law and like oppression, mismanagement, etc. And like the famous Tata case, Mystery Tata, and they hear IBC. And so far, they're giving so much preference to IBC that company cases are fully backed up. So, one, because it will be much faster. If you have, at that time, Finance Minister Jaitley had promised that down the road we will have specialized bankruptcy tribunal. It'll be quicker, and more important, you will have experts, specialized judges, because they'll be hearing nothing but this. So everything will go much quicker. So time. But having said all this and all the criticism, what I have to say is that it used to take 6, 7 years. Now it takes 1.5 years, and everyone is cribbing like crazy. So it is at least 4, 5 times faster. And in the best countries in the world, Singapore, Canada, America, it takes almost the same time. So in time, if we maintain this time, if we don't make it worse, and it is slipping, as I say, admission is slipping. If we stay to 12 to 18 months, actually, we are as good as any country in the world. We don't have to do better. On recovery, from 22, we have gone to 44, 45%. By the way, you guys should follow the IBBI, our regulator's website. It has fantastic information and is done a great job. So, in terms of knowledge management and the statistics, you all should follow that for sure. So it says about 45%. Best in class worldwide is in the 80s. So a lot of room for improvement. And hopefully we'll get there. And the last one is cost. How much does it cost for this recovery? Again, we are world class. From 9% cost pre-IBC, we are at about 1% cost. So we have almost reduced the cost by 9 times. And I dare say, I've not done the analysis, but there won't be many countries in the world that have a cost better than 1%. So, I mean, those are my metrics. Definitely we can improve. Definitely we still have long way to go. But I think the report card is pretty good. And the most important one is culture change. So for this, I have some pretty amusing stories that of course, banks have told me, because who had to bear all this burden were the banks with the NPAs. And that's why I said, unfortunately, it's going to be very busy times, because non-performing loans are again back to 12, 14%, while they should certainly be in single digit. So there are going to be a lot of cases, a lot of restructuring. And previously, first, the banks would be chasing the promoter, and he would hardly show up. When he showed up, he would say, "Aapka loan ka ab kya kare? How do we solve your loans problem?" He's telling the bank. So you owe SBI 1,000 crores and you tell SBI, how do I solve your problem? Today, of course, the guy will be chasing and begging SBI to solve his problem. He is the defaulter. So the culture has completely changed, because they realize that they can lose their company. The IBC bite is so hard and so swift. It has completely changed the culture. And today you realize, when you take a loan, you will not take a loan unless you are very confident of repaying it. And of course, again, I have to tell you all, I'm sure you may already know, that 29A, which debars a defaulting promoter, and it's not all promoters, only if you are a defaulting promoter. So more than 12 months you have defaulted on your loan, more than 12 months. If you have defaulted 3 months, 5 months, 6 months, you can remedy it. More than 1 year, or there are other provisions, criminal charges, etc., then obviously you're not a fit guy to run the company. So we are the only country in the world that debars them from bidding. So therefore you lost your company forever. So it is a very hard stick, and it has changed the culture. That's what the bankers tell me, dramatically. And the number of negotiations, because of the threat of IBC, is even larger than the number of IBC recoveries. So no question, it has helped our banks a lot, and hopefully will continue to help our banks a lot. So having said all this, I want to kind of round up by saying that we still have a long way to go. I mean, the bankruptcy law in the US was in the late 70s. So you can imagine they've had 50 years, and I don't know how many hundreds of amendments. In the UK, it's more than 30 years. So we are barely 5 years, out of which we lost 16 months and counting for COVID. So there's still a lot to do. The potential, as I say, is phenomenal. There will be tons of great cases. And there is also parts of the law, as you well know. For example, the pre-pack regime, which some of you may know about. It has, I don't think, to my knowledge, there's even the first case that has come. This allows the promoter, it tells the promoter, go fast, go early, because the earlier you go, the better the recovery, the faster you can resolve the case. Time is very, very critical. So this is where the promoter has a good chance of rescuing his company and doing a bilateral negotiation with the bank. Then you have cross-border. Already there have been a lot of cross-border cases, like the Videocon case that is going on. Binani, had plans out in Europe. So we don't have a cross-border law as yet. That should come quite soon, I think. We don't have a law, which is very, very important. In every developed country, the law for financial institutions is different from main manufacturing and service companies. It has to be. So we need that. What has happened in Yes Bank, in Diwan, in PMC, in ILFS is a very stopgap arrangement. As the government mentioned to me, when I was arguing about this and saying that we need a proper law for financial institutions, he lost his temper and said that, Behram, you're not understanding. We just want a night watchman. We are not asking you to score runs. You just protect the wicket. You can't let the bank collapse. And then very soon we will come up with a proper law for financial institutions. So hopefully that should be also sooner than later, because we have seen, that there have been a number of cases, and unfortunately there may be few more. So we need this quickly. And finally, of course, we need personal insolvency. Only the guarantee provision has come in, and again there's been so much litigation, but the rest of personal insolvency, which cannot be done by the NCLTs because the numbers will be large, the geography covered, you have to cover, every small city and town in India. So that will not be done by the NCLTs. So they'll probably be done by the DRTs. So that again is a work in progress. So there's a lot that will still happen, I dare say, and in IBC itself. So good luck, wish you every success, and hand over to you for your questions.
Thank you, sir. Thank you for such a comprehensive highlight of opportunities for us, sir. In fact, my first question is something that I'm so glad that you covered it, that IBC is not only about IBC, it is about the other aspects, in fact, other laws, company law, and labor laws, things which one should have a fair idea about. I would like to take it a little forward to ask you how important it is to have an idea of a specific industry, sector, or trade. For example, MSMEs, NBFCs, biotechnology. I mean, to understand an industry, should it be something which should be part of curriculum for the students to understand the application of law better?
Yeah, so that's a great question. I have to say that, again, certainly in the UK and US, I'm sure in many other countries, they do have vertical specialists. So people who know the power sector inside out will tell you about heat rate, will tell you about plant load factor, will tell you all the details about how the quality of coal you need. Same for steel, same for auto. So is it helpful? It is immensely helpful. And there, the verticals are by these. So you will say, I'm a telecom expert, I'm an auto expert. In India, we have certainly not gone there yet. Those firms have thousands of lawyers, so they can do this kind of massive specialization. As a young lawyer, if you can spend some time, I would say this is a USP of AZB, that before we meet the client for the first time, we do as much homework as possible on the client and his business. So, as you say, we learn about the sector, we learn exactly what he's doing. So the first time he meets us, most of our competition, I don't think will make such an effort on that. So they are really surprised. And then, of course, with experience, when you've done a few of those cases, my team that worked on, Tata Steel, obviously today will know much more about steel than I do. The reason I gave you all that about power sector is I worked 10 years in the power sector. So, there'll be, and I honestly, personally also can say that I find that one of the fascinating things about law. So that you learn so much about other sectors. So time permitting, will it be useful? Enormously useful. Obviously, the client appreciates it. Your advice also is more meaningful. Uh, Whether it can be in a curriculum, that's a very interesting question. To be honest, I never thought about it. But I mean, how will you cover unless you start choosing particular sectors? So, you decide that infra has a lot of stress. So I'm going to focus on infra, or I'm going to focus on real estate and cement. If you did, certainly that would give you an edge.
Thank you, sir. Now, I'll also move to a relatively specific question, sir, and I'm sure everybody would also be intrigued to know your opinion on how do you think the pre-packaged insolvency resolution regime is going to affect the way we look at IBC, especially, I mean, vis-a-vis the opportunities under it.
So the pre-pack, we've decided, I think the government very sensibly has decided that last time we started with the 12 biggest cases, as I mentioned. So a new law with the largest, most complicated cases. The advantage was that you therefore got so much good case law from it. But certainly it was like saying, telling a person learning how to swim, jump into the monsoon ocean instead of going in the swimming pool. So this time, I think they have decided that they start, and also, sadly, as I keep reiterating, it's the MSMEs. In the corporate world, I guess the inequalities between the large blue chip corporates and the MSME guys who are struggling to survive, because if they don't get paid, they have no cash flow to maintain them. So it is really for them. Also, because in the MSME sector, all the banks have said to me, besides the promoter, there may not be other bidders. So you will have massive amount of liquidation, and you don't want liquidation because it leads to a lot of job losses and it's a waste of the assets, the plant, machinery, etc. So the goal is to start with the smaller cases. As I said, there's a big incentive because the promoter can then keep his company. Here, he doesn't have to he's not stepping aside. The IP is not taking over his company. So it should be a win-win. For the bank, you don't have to go through a long IBC process. It's supposed to be much quicker. And for the promoter, I'm saving my company. So I'm cautiously optimistic. It should definitely work, and I look forward to the first few.
Thank you, sir. Thank you, sir. I'll now quickly start taking up the questions. The first question is from Mahima Malhotra. She's asking, what is the scope of clearing limited insolvency exam? It is very specific, subject specific. Limited insolvency exam conducted by IBBI, other than becoming a resolution applicant, or sorry, it's a resolution professional for a young lawyer who wants to specialize in IBC litigation and restructuring.
No, I mean, if you want to be an IP, then obviously it's a must. If you are for sure you don't want to be an IP and you just want to be a lawyer in IBC practice, then it will give you a lot of domain knowledge because you will study that subject intensely. I don't know whether, in law school they are teaching that subject as of now, or you will have to learn on the job when you are working as a lawyer. So I mean it's a tough choice, to be honest.
I'll quickly move on to the second question, sir. It says, considering the increase in compliance requirements and everything becoming subject to certain regulations, don't you think that disputes will decrease eventually? It's about
I
bread and
wish,
butter.
I wish. No, unfortunately, I don't think so. But I hope you're right.
Okay, so one Miss Ananya Singh, she's asking you advice for law students which are not much exposed to IBC, of course, who aim to join IBC practice at firms like AZB and Amarchand. So I'll just add. I mean, these are repeated questions by many students here. What do you see in a student or an applicant or a candidate? Is it about competency, intelligence, hard work, passion, or integrity?
All of the above. So, unfortunately, it's in the real world, what happens is that, and the time constraints that everyone has, the first cut is purely on the grades. I have to be honest with that, because what happens is there are hundreds of applications, the HR team goes through that, and then they will pass on to the interviewing committee, the ones that make the cut on grade. So sadly, that is the first cut. Once you've made that cut, then it is definitely on fire in the belly. So how passionate are you? Integrity for sure, because imagine if someone who is brilliant, very ambitious, but is a crook. I mean, that would be a recipe for disaster. And then, to be honest, also for us, AZB, the culture. So you may be a superstar, but if you're a solo superstar, if you're not a team player, then by all means, good luck to you and be a solo. But if you're coming to a firm, you have to be a team player.
Right, sir. Well taken. So the next question is from Vishesh Gupta. He's asking, what is the scope of mediation or ADR in insolvency matters?
Yeah, great question. So internationally, it's quite big, and they do this in India. Again, I should add that to my list of to-dos and what we have to aspire to. So far, I don't think there is much of that in India, but internationally, it's big.
Well, sir. Now there's I think, three sub-questions here regarding opportunities available in the specialization. It says, are there IBC-focused teams in law firms, distressed funds, financial firms? Are law firms looking to build teams focused on IBC? And of course, the third facet is LLM specialization. I think one wants to ask whether it is beneficial to pursue it in IBC practice.
Yeah, so teams, yes, there's no question now. All the major firms who are practicing in this area will have teams that do nothing but IBC, because, as I said, there's the demand. There are so many cases. So the lawyers, as I said, in our firm, and maybe in the other big firms in our peer group, they must be doing entirely IBC. For us, I would always tell my team, keep at least 10-15% margin for other stuff. So suddenly, if IBC, like, in the COVID times when there was a suspension of the act, so always keep some other work that you are competent to do. But we definitely have IBC team. LLM, yeah, always a good idea. I mean, as I said, I am unfortunately not aware how much the colleges offer, but LLM would definitely be beneficial.
Right. So I think may I add? I'm doing this audacity. Uh, I think one must go to IBC or any specialization. One has done a little bit of practice, maybe in house or in a firm. I think that would be, one can imbibe it better.
Much better. Absolutely. I should have said that. That to get the best out of a LLM, you should have minimum 2 years of practice. And we certainly tell all our lawyers that 2 years minimum. Normally you don't do more than 3 years, because then you're upsetting your career. So you go in the early years, finish the LLM, and I'm very proud to say that the vast majority come back.
Thank you, sir. So next question is from Alicia. She says, I think this is something which is faced by all the students. What would be the practical difficulties that arise in the initial days of if one chooses the path of litigation in IBC, and how do you suggest one can overcome it?
Yeah, so as I mentioned, you have two ways. One is to join a firm, and then it's not such a big deal because you will start like you would start as a litigator in any other area. You'll be doing the research, you'll be doing the first drafts, and there's again more than enough work. I mean, as of now, I think we have over 70 IBC litigation cases ongoing day to day. So there would be no issue, and you would pick up very fast. If you wanted to go straight into a council chamber, then you have to find the right chamber, obviously, because then it's your senior there who will train you, and then take it from there. Which you are much more of an entrepreneur, because basically you only earn when you get a client or when they share the fees with you. So it's more difficult in the start, but there are brilliant counsel, and I'm sure the training is wonderful. So in a long term, it's a superb future. And once again, because this is such a new space, I don't think there are many counsel who can say we are specialists in IBC. So only people like you who have started in 4 or 5 years, you would, know as much as any other counsel across India.
Very well, sir. Thank you. I think the time does not permit us to take more. There were a couple of more questions. There were more subject specific, sir. I think we'll have to wind up our Q&A here. And I'm sure that everybody has benefited and has a far better idea about the opportunities and what efforts one needs to put in to get into this practice area. Quite niche, but yes, it needs an integral effort. Sir, of course, on behalf of everybody here, I thank you for your insights today, sir. And I'm happy. I'm happy that students have asked the questions. I'm happy to moderate such keen and phenomenal audience. And this is one of the pertinent aspects, how you get into a certain field. And above all, it is never too early to begin to prepare for a successful career. Sir, I would especially thank you for taking your time out for all of us, including myself. It's quite an inspiration to be talking to you for all of us. And it's really an honor.
Thank you so much. Thank you. Thank you. Very kind. Thanks a lot.
Bye, sir.
Thank you,
Bye.
sir.
Thank you. Thank you.